you're going to get a choice. You're either going into inpatient treatment, either way, you're going into custody today. All right, are the parties ready on David Vargas? Where's David? All right, where's, yes, has the information been uploaded? All right, so if you all will step back a little bit. All right, we're going to go on the record in 2018 CR 5087, State versus David Rodriguez. And if you all will re-announce, please. All right, and are you Mr. Vargas? All right, so you had entered pleas of true to number one, and it's driving while license invalid. And also to a violation of condition number two, consuming alcoholic beverages. All right, and probation is leaving it up to court as to what to do with your cases. All right, I'll hear argument.
We're asking for revocation. By the way, that's fine. This is secondary felonies. I know the court has read the stips from that case, but the facts are really bad. The victim says in the stips that she heard and after he killed her, he threatened her and threatened his own brother with a knife. So apparently a scary offense. He gets deferred on that charge in 2018. And he hasn't been doing the right stuff since he's been on the deferred on it. He's got a pending life. He pled true to drinking alcohol while he's on the deferred honor. So we are asking for revocation at this time. If you are not inclined to revoke him, we would ask for status and aftercare, which is a previous recommendation of probation, or at the very least a jail sentence. This is a very serious offense that he's on for adjudication, and he's not doing the right thing. This is what he's still pending. The DWI is inherently a dangerous offense, Your Honor. It's dangerous to the community. It's dangerous to himself. He also had folks in the car when he was driving, so inherently dangerous there. That's why we're asking for that.
All right, defense.
Since this has happened, heard from your CLO will be sent to evaluate. He understands what he did with his plaintiffs. He not have the blood results back on the DWI. I believe that the difference true. But we believe Your Honor, the admission of the vehicle is a probation. That he understands the mistake he's made.
All right. So I understand that the state is talking about what's in the stipulations, but really what we're here on is he drank alcohol and he picked up a DWI. So here's the thing with regards to your request, you're going to get a choice. You're either going into inpatient treatment, either way, you're going into custody today. You're either going into custody for inpatient treatment, and I know there's a pending DWI, and you're going to be waiting until that DWI is resolved, or I will sentence you to 4 years in the prison. Okay, he doesn't seem like he wants it. He's sort of like,
No, it's just, I'm just having your time. I figured a bit at the beginning of this when I first put on probation. I did while I sat in there for 2 months waiting, I took classes, like maybe classes in there. I found out that well, I found me at church. I do 80 meetings, I do more than that required. I'm trying to figure it out.
no, I understand, but here's the problem. And I will tell you, with regards to the stipulations, that's potentially be considered if you're going to prison, like what would be appropriate. So, I mean, you're going into custody today. You're either going to, I'll let them consider maybe felony drug court will accept you. I don't think they will for the nature of cause, due to the nature of the cause. But Yeah, you're not going home today. So if you want treatment, you'll be going into treatment. Or if you want prison, you'll be going to prison. So which do you prefer? I'm sorry? Okay. All right, and I will note that you've actually been on probation since 2019, and this is the first motion to revoke I've had with you. All right. So I'll deny the motion, alternate amend conditions to include SATA. Well, we'll start with to include a referral to felony drug court, and that's to be in custody. If felony drug court doesn't accept him, then SATA, and he's to remain in custody until transfer. Is there anything else? That's Judge Glenn. Yes. Okay. Okay. All right. Yes. Okay. Yes. Yes. All right. Thank you. They'll do an application. Court is calling 2024 CR 2632, State of Texas versus David Keller. Can I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Defense?
Di pa kayo Carrillo?
And are you Mr. Keller?
Yes, Your Honor.
Counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Keller, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we're proceeding on count one, waiting count two.
Any objection?
No objection, Your Honor.
Showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand in count one, you're charged with unlawfully carrying a weapon with a felony conviction? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Counsel, has your client, I'm sorry, sir, just 1 second. Is that? Okay. All right, thank you. All right, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe so, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
In my opinion, he is, Your Honor.
Mr. Keller, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain agreement. Did you review that with your attorney? Did you understand it? According to the plea, punishment is to be assessed at 2 years in the prison. There are no applications and the weapon is to be destroyed. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State? Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Then to count one, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State, any evidence? Any
No
objection?
objection, Your Honor.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Is there anything you wish to say on behalf of your client?
Your Honor, my client just, wishes to, just put this case behind him. That's why he came to a resolution today, and, he has another case that he's already been sentenced on. And so he would like this case to be running concurrent with it.
And what is
Out of
that
B
cause
County?
number? Do you have the cause
No,
number?
I do not, Your Honor.
And which county is it out of?
Is B County?
B County.
BEE?
Yeah,
Yeah.
yes, Beville.
And, one other thing, Your Honor, my client, has been in continuous custody since he was arrested in November 18, 2023. However, B County, bench warranted him for about 46 days, and then we bench warrant him back. So I would like to, Your Honor, consider that he's been in continuous custody since, November 18, 2023.
All right, the court then will sentence you to 2 years in the prison, give you credit for any time served. The weapon is to be destroyed. This will run concurrent with your Beeville County case, and credit is to begin from November 18th, 2023.
Thank you, Your Honor.
You're welcome. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
This one, thank
Did you understand it and did you sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. How old are you?
30, Your Honor.
All right, you're 20 more years. You're going to be in the twilight years. You need to make a decision whether or not you want to spend the rest of your life in prison or not. You understand?
Yes, Your Honor.
And don't go there and become institutionalized. I see the tattoos. I know what they mean. So you better get your life together. You understand?
Yes, Your Honor.
All right, good luck to you, okay?
Thank you, Your Honor.
You're welcome. Are
May I
y'all?
be excused?
Yes. Are y'all ready on eds? All right, court is calling 2022 CR 6641, State of Texas versus Christopher Joe Medina. Can I have parties announced for the record for the state?
Second for the state.
Defense? Are you Mr. Medina?
Yes, Your Honor.
Going to show you what's entitled motion to revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Christopher Joe Medina who was placed on community supervision in 2022 CR 6641 for the offense of criminal mischief, $2,500 to $30,000 on November 15, 2022 for a term of 3 years? Is that you?
Yes, Your Honor.
State.
Your Honor, violation of condition number 2. On or about the 20th day of October, 2023, in Bexar County, Texas, the defendant, Christopher Joe Medina, did then and there consume alcoholic beverages, namely alcohol, in violation of condition number 2.
How do you plead to that? True or not true?
True. True.
All right. Are you sure you want to plead true to that?
I think the confusion, Judge, I thought he was gonna read the diluted and not the alcohol, but it's fine.
All right. Are you pleading true to that?
True. And then, Your Honor, the state will waive and abandon the other violations.
Any objections?
No, Your Honor.
Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, and sentence you up to 1 year in the state jail facility?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, ma'am.
All right, your client seems as though he does not want to go forward with this.
I think he's just nervous, Judge. He knows what the agreement is and he's satisfied with the agreement.
All right, did you understand by pleading true to violation of condition number 2, court could find it true, grant the motion, sentence you up to 1 year in the state jail facility?
Yes, ma'am.
So if you have an agreement with the state, court doesn't have to follow that agreement. Do you understand that?
I understand.
All right, the court will find violation of condition number 2 true. Is there a proposed agreement?
There is a proposed agreement.
And what is that?
It's essentially for revocation and adjudication via a judgment satisfied. And counsel and I spoke, and basically there's other violations that, again, we've already waived and abandoned. namely a couple of which that I don't think I think the state's gonna have some difficulty proving up at a future date and time. So just given the nature of what we proceeded on in terms of the violated condition, and given the potential, there may be some discussion on the actual days in, but given the potential great number of days in, we had a proposed agreement for, again, a judgment satisfied, Your Honor.
So what time are you all speaking about?
Well, just we're asking for 30 days. I think the computer is incorrect. It shows 361 days credit, but I don't think that that could possibly be correct because I know how much time he's actually spent in jail,
All right, did you all confer with probation over this?
over how many days he had. No.
No, I mean, over what you all are proposing.
I had let Vashon know that we essentially, again, we're gonna have some difficulties with other things with respect to this defendant in the future. So given just a violation, we would be proceeding on the idea of revocation, adjudication, and a judgment satisfied.
Your Honor, the probation standpoint is for revocation.
All right, so then the question is time. So I want to know what he's actually done on probation. Do we know?
In terms of his time, Judge,
No, I mean, what he's actually done on probation.
he's completed everything. Judge.
Well, we're gonna hear.
I can-
He completed outpatient treatment, Judge, in December of 2022. Anger management, parenting classes. Those are all of the classes that were mandated, so he's completed all of the classes. Community service hours is at a 0 balance. He has paid off his fees. And his latest UAs have all been negative.
All right, and when was his last UA?
Indicates on the court summary was February 20th of 2024.
All right. You give me a UA today, what's the result going to be?
Negative, Your Honor.
All right, let's do a UA.
Yes, ma'am.
Can I step up?
And yes, and then I'll make my decision. All right, who's here on David Vargas? Who's the attorney for David Vargas?
Michael Goins, Your Honor.
Okay. All right, everyone, behind the court reporter, we're going to go on the record. Court is calling 2018 CR 5087, State of Texas versus David R. Vargas. Could I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Michael Dwight Goins for Mr. Vargas, Your Honor.
And are you Mr. David Vargas? Are you proceeding with this MTR or is it going to be contested?
Your Honor, we've already finished the MTR. He pled true, you found it true, and we're here today just for sentencing.
All right. Ah, that is true. So on March 21st, he pled true to a violation of condition number 1, which was the driving while licensed and invalid, and violation of condition number 2, consuming of alcohol.
That's correct, Your Honor.
All right. All right. Is there anything you wish to say on behalf of your client?
Yes, Your Honor. My client is currently in college. He's pursuing his degree. He's trying to get it done in psychology. He's had an initiative.
Just one moment. Everyone, we're on the record. No talking behind the court reporter. If you would like, the deputies can move your person to the end. All right, you can continue.
It's part of his pretrial in courtroom 6, in county court law number 6, excuse me. He has an ignition interlock on his vehicle. There's been no violations of the ignition interlock as of this time. And Mr. Vargas would understand, he would like, if you would continue on probation, he'd fully understand if you'd like to make the ignition interlock part of that probation in the future, Your Honor. And that's all we have, Your Honor.
All right, anything from the state?
Your Honor, we're asking for revocation. I know you've read the steps on the underlying offense, Judge, but in the steps for the underlying offense, the victim told police that she could hear gurgling when the defendant choked her. And so
Your Honor, I don't believe that's relevant because we're here for the MTR, nothing for the underlying.
Well, I
case.
think it's relevant to the defendant's state of mind, Judge, so he knows he's on deferred adjudication for this crime. Where the defendant heard gurgling when he choked her. And instead of complying with the terms of his probation, he went out to the comedy show, drank alcohol, which is one of the things he pled true to. And he's now pending a DWI. He pled not true to that, but that charge is still pending. We didn't waive that or TIC that as part of the NTR, Judge. So we are asking for revocation and that you sentence the defendants to prison, Your Honor.
All right. And probation on this case, it is David R. Vargas. What is probation's?
System is down at this moment and I cannot pull any information. If you would, give just a second to look over the
Okay,
court summary.
yes. All right, I tell you what, if you all will have a seat for a moment and let's see.
Yes, sure.
Yeah,
Just give me
yeah.
like 5 minutes.
Okay.
Oh, no, just how long the system takes. So just have a seat. We'll see if we can get the system back up, okay?
Thank you.
All right, you're welcome. Well, we can go on the record. Court is calling 2019 CR 0687 State of Texas versus Jesus Resendez. That party is announced for the record for the state
Ruben is for the state.
defense.
Tilden Schaefer, Mr. Resendez, John.
All right, and are you Mr. Resendez? All right, the defense is filing a motion to alter and amend your conditions to not have you in inpatient treatment. The court has reviewed the motion to modify conditions of community supervision. Defense, have you had a chance to review that?
Yeah, Your Honor.
All right, are you in objection?
No, Judge, we are in agreement.
All right, well, the court's in objection.
Yes, ma'am.
And let me explain to you why, Mr. Resendez. You were placed on probation on August 15th. And at that time, the court ordered intensive outpatient treatment with probation. Then you came back on March 21st. And you pled true to violations 2, 2, and 2. The court denied the motion, alternate amended conditions to include the UA hotline, and they were to test you for levels and do field visits and have weekly Zoom reporting or in person. And you were to do a UA on March 21st by 1:30 p.m. Then the court got this supplemental report. And the supplemental report says this. As an original condition of probation, probationer was ordered to complete outpatient treatment program with the probation department. He attended outpatient orientation and was provided a start date, but never attended class. MTR was filed for technical violations. Probationer appeared for a hearing in March. The court denied the motion to revoke, amended the conditions for IVR hotline, random field visit 2 times per month, and weekly reporting. Conditions also included monitoring THC levels, and if the probationer tested positive for other than marijuana or missed the hotline call, amend conditions for Bexar County ISF. Probationer has not consistently called the hotline, and of the 5 urine samples submitted since the hearing, all were positive for marijuana. TAP evaluation was completed and the recommendation was SATIF. Probationer agreed to attend SATIF and signed amended conditions. It should be noted that the probationer is on for a Title V, therefore does not qualify for ISF or SATIF placement. State ISF, both tracks will be an appropriate sanction. So I don't understand why I shouldn't send him to ISF. He's not doing what the court's telling him to do.
And if, may I?
Yes.
Judge? So to kind of go back over what you've said, Judge said, he was placed on probation in August of 2019.
Mhm.
And then he started having some trouble, and I don't know the timeline exactly. I know the court probably has that. But I do know that the MTR was filed in September of 2020. I represented him on that MTR, which we came to court on.
Before you continue, if you're drug tested today, what are the results going to be?
Negative.
All right, we're going to do a drug test today. Then we'll come back.
Okay. wanna
So
do
that'll
that
say,
now?
yeah, we're gonna
Yes,
do it
that-
now.
That's.
So then you can save your argument.
Yes.
We'll see what
I have to
happens.
remember all these dates.
Okay.
They're gonna just wait for them.
Do you need any water?
Unfortunately, I went to the bathroom 10 minutes ago.
Do you need water?
Drink some water, drink some.
Yeah. I'll put this in.
Okay. All right, thanks.
I'll let you.
All right, thank you.
No, the court has other business or not. I've shown this to the state. I don't know if you want to look at this now.
Sure.
And I can kind of.
I'll let the state know, see if the state has any objection to me viewing that. You?
Make me feel better.
All right, bring us.
He doesn't.
Mhm.
You want me to just give you a quick preview?
Oh, no, I'll read it. Yeah.
I think it's so.
Okay, thanks. Hi. All right, good morning. All right, we're here on Bring Us. State, they filed a motion to amend conditions to remove the no contact order to no harm or injuries. Do you have an opposition to that before we go on the record?
Your Honor, I'm not opposed to it. I did speak to the victim and she's pregnant and she has no family or anybody here. So I think she's wanting him there. She's also said statements that will cause me to reevaluate the case, Your Honor.
All right, so what the court could do, and we're not on the record yet, I could have him not live with her, but he can still have contact with her.
No, because when I met her, we started married together was because I'm in the army, so I'm with my friend on the couch. Because I'm paying for everything for it to stay with. I'm paying for everything else for her to be with. And she'll will be born next month. Like in 3 weeks.
State,
Your Honor, I just overheard that they are living together currently, so
No.
No?
Yeah, I'm living with my friend.
Yeah, and she.
And
oh, she would
stays-
move in there,
Yeah.
okay,
That's the only place she has to live.
okay.
Because I'm paying for the house.
Your Honor, there's another person living there. A friend living there?
No, I'm living in an apartment with my friend.
Right.
And she's staying in my house.
Oh, so you would move back to your house.
I will be the one moving back.
Your Honor, I think it's a good idea to keep them separate until I can fully evaluate the case, but I'm okay with him being there for the labor, being there for the baby.
all right, so this is what we're gonna do. I'm gonna put the order as no harmful or injurious contact. They're not allowed to live together. We're gonna call this case back. How much time do you need to evaluate?
I need to just read the offense report at a minimum, and see if it corresponds with what she just told me.
All right, so are we able to do this in 2 weeks, maybe?
I think, yeah. For sure.
All right, so this is what we're gonna do. I'll put the order at no harm. Well, here's the thing, Mr. Bringus, you're here not because of something I've done, not because of something the state's done or your attorney has done. It's because whatever's happened to your relationship.
No, yes, I understand that.
Yeah.
It's just like, what worries me is like, the doctor told her in 3 weeks, it's just at any time, so I'm just kind of worried about.
Well, that's why we're coming back in 2 weeks. All right, and if the state has some information before that 2-week time period, I'm sure they'll call your attorney. Everybody here has each other's phone numbers, and I'm sure your attorney will call her. But part of my job is to make sure, to the best of my abilities, that people are protected.
That's all I understand.
I don't know anything about this case. All I know is what the charges are.
Understand.
So that's the reason why I said, for me, I wanted you to at least have done some anger management. Now, I asked you to do that anger management. Do I know if the facts in this case are true? No, because I don't know 100% the facts of the case. The state is in agreement to there being no harmful or injurious contact. They were in agreement last time to no harmful or injurious contact. I'm the one who said, you need to do some classes before I will allow that. So I will let him have no harmful or injurious contact with her, but he is not allowed to stay with her.
Yes, Your Honor.
Now, we will come back in 2 weeks. The state will have an answer, hopefully, of what they will do with this case.
Yes, Your Honor. Thank you.
Ms. Ferguson, can we have Mr. Bringus back in 2 weeks? And if you could give them a reset for him? All right, so we'll be back on the 23rd.
Your Honor, will you want the complainant present again as well?
She doesn't necessarily have to be present. I mean, unless someone wants her here.
Thank you, Your Honor.
You're welcome. Yes, you can tell me before we go on the record, what's the announcement?
The district attorney is willing to withdraw the MPR as long as he pleads out on the name number 1 that he's got out of County Court 12, a DWI case. And that is set for March the 7th, but they're asking, or we're asking, if it's possible for us to come in or have a date after March the 7th, because this will.
All right, so let me ask you this. What is the anticipation of what will be happening in County Court 12?
A plea. And we have already asked for a Padilla letter, and that's what was holding us back. And he should be getting his Padilla letter pretty soon. As of, we just spoke to Herman yesterday regarding that matter. And he's the one that said, well, give me X time for that Padilla letter and I'll plead him out, because I want to plead him as soon as possible because it resolves his felony MPR.
All right, and so is this not to interfere in your negotiations in county court, but is this a plea for probation or something else?
Probation.
Oh, okay. And I ask this because I know that judge gives, if you're going for jail time, it's not going to be a judgment satisfied on a
Right.
DWI.
And it's a low score. And I have been communicating with them and they're on board with offering him probation.
All right, and so you're telling the court that this will be accomplished on the 7th of March?
It should be on the 7th, as long as we get that Padilla letter, because she also requested a Padilla letter.
Who's doing the Padilla letter?
I think that Lady Torres maybe.
Do we know for sure?
Yeah, well, Herman said that he already,
All right, so it's Teresa Close Davila. Have you spoken to her?
not about this client, not recently.
Yeah. She hasn't been, I don't know if she's been appointed on this case because I don't have him as down as needed in the immigration. So does he have an immigration attorney for the misdemeanor, yay or nay?
Yes, he does, just for misdemeanor.
All right. And has he spoken to her?
Hablaste con su abogado de inmigración, ya te llamó.
Oh, Mr. Martinez, that's why we have the interpreter. I mean,
Yes, I did.
okay. We don't have 2 interpreters.
You're not old enough, Judge, but for the first 20 years of my practice, we didn't even have interpreters. And there's still small counties
Mhm.
that there's no interpreters, just
Oh, wow.
bigger cities.
Well, try as I've had where I represented a client before and they had an interpreter and an advocate. And the interpreter and the advocate got into a heated argument over who was interpreting correctly.
Judge Perez, on the 293rd in Zavala County, would make us on a felony plea to interpret.
Oh, wow.
And there's some words there that I would pull out my Spanish dictionary, I couldn't find it and stuff like that, admonishment, stuff like that. And he would make us interpret
Oh, wow.
the whole, and he, I don't know if you know about him, he would take 30 to 45 minutes to do it.
Oh, wow.
So there we are.
All right, so Mr. Martinez, have you spoken to this person, Ms. Torres?
No. Linda Munoz, with Linda Munoz.
Oh, it's Linda Munoz. Is that your immigration attorney for?
Oh, no. An officer. He's an officer.
I'm getting confused with the probation officer.
No. Who is your immigration attorney?
I don't think Davila has spoken to him, Judge.
Well, she hasn't been appointed in this court.
Not in this court, you know, because now it might be moot because if they withdraw it. But I have also asked on this court for her to be appointed. But that was done recently, and out of County Court 12, was speaking to Herman yesterday. He already has her on that it got approved for California.
All right, so this is what we're gonna do because I can't depend on that. Ms. Ferguson, can you see if there's an immigration attorney? Yes. All right, can you call Ms. Davila? Just see if she can, just call her and see if she can talk to him today. And what we can do is, counsel, you can have her number and your client can speak to her, and she speaks Spanish. And so we can have a interpreter, and we know he has an interpreter, so we know that this will happen in March.
Okay. He keeps telling me that I already have my own private immigration lawyer because he's doing my paperwork. I don't know if he can produce a Padilla letter for him.
All right, well, the issue is whether or not that immigration attorney is working on his global immigration case, or if that is an immigration attorney who's working on the impact of these cases.
He says that he's doing the paperwork for asylum.
All right. So,
So he just went to his office and he got renewed a 2 years permit to stay here for a political asylum.
all right, so this is what we're gonna do. Ms. Ferguson is gonna speak with Ms. Davila. You're not gonna leave here today until you've had a chance to speak to Ms. Davila. And then we will come back on March 7th, but you'll do your case downstairs first.
Okay.
All right, so Caroline, can you give him a reset date for March 7th? And put on there 11 a.m. That way everybody will know he's in County Court 12 first. And then don't leave before Ms. Ferguson gives you the information on Ms. Davila and you talk to her today.
But there is my motion asking for an immigration lawyer on your case, right?
They're telling me it's already, look, this court is so great. Yes, it's in here and it's for February 3rd.
Besides that,
So she's going to give you the information to talk to her. So
okay.
just hang tight and we'll make that happen.
Yeah.
And if you get the reset form, but do not leave the courtroom.
Okay.
Thank you so much for coming down. You too. We've had, interpreters just popping in. So that's awesome.
It's Friday.
Yeah, it is.
Okay.
All right, you too. All right, what is happening with this case?
So, Judge, I'm appearing with Mr. Brodnick today. He's
Okay.
starting a jury trial tomorrow on a civil case and asked me to appear for him.
All right, why were you late?
I went on the elevator like on second and then third floor, and then I finally found the 187 at the end of the.
Okay, so here's the thing. Now you know where it is. Can't be late anymore. You understand?
Yes, ma'am.
All right. Ms. Ferguson, on this case, let's recall this back. Are you employed?
No, ma'am.
All
I'm
right.
Full house arrest.
I'm sorry, what?
I'm full house arrest.
Okay. Ms. Ferguson, let's recall this for the week of May 6th.
And Judge Hank's going to give me an offer today.
Okay. All right, we're going to come back on May 7th. And once you sign the reset form, you will be excused. All right, the court is back on the record in 2022 CR 6641, Christopher Medina. All right, probation tells me the results are negative. So I will follow your agreement. And is this 30 days in the Bexar County Jail?
Yes, Judge, he did actually spend that pending the NGR before he posted his bond.
All right, court will sentence him under 1244 to 30 days in the Bexar County Jail. Are you waiving your right to appeal?
Yes.
All right, and the court will give you credit for any time served, and the court will show that the judgment is satisfied. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand? All right, we can go off the record. Good luck to you. And I like the fact that I always tell the attorneys, mix it up a little bit with your clothing attire. So I do like those pants.
I told you both.
All right, have a good one.